Hello, everyone. This is Tracy Siska. Welcome to the Chicago Justice Show. Thank you so much for joining us. We're excited today. In the first segment, we have Jobi Cates, founder and executive director of Restore Justice Illinois. We're going to be talking about the big omnibus bill that passed, HB 3653, I believe it is. It's an 800-page bill. Last week with Sarah Stout from the Chicago Council of Lawyers, we talked about some of the policing implications. Today, we're going to talk about how that bill impacts corrections, those incarcerated in the Illinois Department of Corrections, and some community supervision aspects to it, too. It should be very interesting. The bill's huge. I recommend that you all read the bill yourself or choose the media that you choose to believe about what's in the bill. There's been a lot of doomsdayness among the response from the police and the FOP here, the Chicago Police, the Illinois Sheriff's Association. We'll talk about that a little bit later. If you want to get involved in looking at policy and analyzing it and trying to move things forward, every Wednesday, we are what we call our CJP Nation, our advocacy wing of our organization, meets every Wednesday evening at 7 p.m. Central. Basically, this group does a bunch of crowd-based research projects. They help us with policy. There's going to be some movement on our police settlement transparency and accountability ordinance in the city council. At least we started to hear rumbles about that, so that may heat up soon. But also they do big research projects. Like two of the big things that are going on right now is we have groups looking at this alternative response program called Cahoots in Eugene, Oregon. They were on the show recently. We had a couple of people from the show recently on, and then also the Milwaukee Homicide Review Commission. We want to propose similar projects to those two in Chicago, but the groups are researching how those programs work and then how they've been replicated across the country, how they're working in other cities and other states, so that we can fine-tune our proposals to propose things like those programs in Chicago. Another thing is a legislative agenda dealing with this bill, where we have a bunch of group of researchers looking at all the requisite reports, the Police Accountability Task Force report, the consent decree monitors reports, reports from the Police Executive Research Forum and the International Association of Chiefs of Police, Obama's 21st Century Task Force, and helping us fine-tune what we're going to call legislative agenda for accountability. I've helped architect the police accountability system in Chicago, and much of that has been an absolute failure. We have to get away from relying on the police accountability system and head towards one of the things in this bill is heading towards, if you don't want police to do certain things, make them crimes, make those activities crimes. In this bill that we're going to be talking about today, but just on the incarceration part, knowingly turning off your body camera to hide information, or lying in a police report, or knowingly letting another officer lie in a police report can be a Class 3 felony. That's significant progress. We want to add to that. So, by all means, join us tonight. If you want more information, you can email us at info@chicagojustice.org, and we'll get you information. We'll get you the link for tonight. All of that's not a problem. Also, just so you know, this is our last episode on Wednesday afternoons at this time. Starting next week, March 1st, we move to Monday, Wednesday, Friday at 5:30 Central, 3 times a week. We're going to try to have one show focus on the media and crime reporting, violence reporting, both locally and nationally. The Wednesday show is going to continue to be an interview show focused on what's going on locally in Chicago and Cook County in Illinois. And then the Friday show is going to focus similar to Wednesday, but the Friday show is going to be focused more nationally. So if that is something you'd like to support, you can also get to us at information at info.chicagojustice.org, or go to our website and you can donate to support, sponsor the show. We would really appreciate it. Next Monday, we are featuring Jonathan Ballew, the first in our inaugural shift of the show, a local journalist, freelance journalist now in Chicago, and also a law student. And we're going to talk to him about his experiences being on the street covering the George Floyd protests. We're going to be also talking to him about his response to the Inspector General's report about the Chicago Police Department's handling of the George Floyd's protests and the activities of the police department. I read some of his stuff on Twitter. He's a great follow. He has some interesting context, and not context that is actually based on being there. He was a great read in the stuff that he wrote. I highly recommend, if you want to know more about what was going on, to look his stuff up. I think he wrote for some national outlets. I know he wrote some stuff in the Chicago Reporter. But I highly recommend you join us next Monday, 5:30 Central, for that. We'll be back right after this with Jobi Cates from Restore Justice, Illinois.
Join a group of engaged and committed individuals advocating for transparency and accountability in the local justice system around the country. Get engaged through crowdsourced research projects, digital activism, public policy advocacy, or become a social media ambassador. Our criminal justice system will not reform itself. Communities must demand it. Transparency can be the fuel for justice our local communities need to combat the weaponizing of data by our justice system. Transformation of our justice system cannot occur until we know exactly what they are doing and who they are doing it to. Get involved today. CJP Nation.
All right, we're back. I'm so happy to bring back to the show. She was on one of our first shows, which seems like about 5 years ago now, but it was only several months ago. Welcome back, Jobi Cates. Thank you so much for coming on again.
Thank you for having me. And now time is meaningless these days.
I know. Ain't that the truth? It's amazing to think that we've all been, or many of us, I shouldn't say all of us, many of us have been basically locked down for almost a year. Who would have ever thought
something
you could do it? Right? But the sun is rising a little bit. Like, I am confident we will not be in the situation 12 months from now.
I agree. There's a light at the end of the tunnel.
There is, and we got confidence in the White House that's less than a mile away from where I am coming from. Thank God. Although we're posed because we're getting told in D.C. that next Thursday is going to be a bad day in D.C. because the 4th, there's more insurrectionists planning to come to D.C., which is why I'm getting Huey helicopters over my apartment pretty regularly now.
Oh, boy. That's frightening.
Yeah.
Well, take care.
Welcome to D.C. Never thought I'd get that when I moved to this nation's capital. Okay, so for our listeners who don't know, can you give them the elevator speech on what Restore Justice Illinois does?
Sure. Restore Justice is an organization founded by lawyers, family members, and friends of people who originally had sentences of life without parole for things they did when they were young, when they were kids in some cases. And that little group of people stuck together. And in 2012, following a U.S. Supreme Court case called Miller v. Alabama, we band together as a part of a coalition to start a legislative push around really kind of excessive and extreme sentencing regimes for young people, which are also, tell you a secret, they're bad sentencing regimes for grown-up people too. But we started our focus with young people. And now we have 2 entities. We have a 501c3 called Restore Justice Foundation, which does research and communications. And we have a growing network of men, unfortunately no women yet, who've been released after more than 20 years, who assist in our work. And we have a C4 called Restore Justice Illinois, which does the lobbying and a little bit of electoral work to try to promote sort of fair public safety and criminal justice reform policies.
Okay, so we're talking today about this big 800-page bill. I'm calling it HB 3653, this omnibus bill that passed, that was just signed into law yesterday. So how involved was Restore Justice on pushing this? And how long of a push was it? How long were you involved for in this campaign?
Well, it's interesting because, it was really about a 5-day campaign, because the bill didn't drop until the first, the night before the 5-day lame duck session in January. Shortest campaign ever. I'm hoping someone out there is laughing at that joke. In reality, what an omnibus often is, and what this omnibus is an amalgam of, in some cases, decades worth of legislative proposals and ideas that have been through the process at some level and haven't passed yet. And there were very few totally brand new ideas in the omnibus. So the piece of the bill that we are responsible for is the felony murder reform. And that is something we've been working on really in depth since 2018. So not very long compared to some of the other pieces of the bill. But our work on felony murder reform involved Senator Peters, who is one of the champions of the legislation, and Representative Slaughter, who is the House sponsor. So when they were deciding what went in the bill and what didn't, and what was going to get negotiated out as negotiations with opposition heated up during those 5 days, we were really grateful that felony murder stayed in, and we were, as involved as we possibly could be without the traditional tools at our disposal, when tools being showing up and walking around and following people. We couldn't do that. So we had days of action. We had really extensive social media trying to remind people of some of the really horrible felony murder cases over the past several years. This is why this legislation was so important.
Okay, let's get into the weeds of what has passed here, because I think the media doesn't get into the weeds enough, and then they're too reliant on sound bites from pro sides and anti sides. Yeah, this reform is great. The sky is falling. Criminals are going to reign. Right? Yeah. It's the end of policing in Illinois.
And neither of those things are really true. I mean, it's something in the middle, right? It's a great step forward.
It always is. It always is.
And it's not the end of the world.
You never get what you want. Yep. All right. So we're going to start right away with the narrowed scope of the felony murder law. So for our viewers, quickly, what is the felony murder law, so they understand what it is and what changes has come about as because of the passage of this bill?
Yes. So the felony murder rule is actually a really old, it's a really old part of our criminal statute. It's been around really as long as we've had a criminal statute. And it's I would say, archaic in that we had a law that allowed an individual to be convicted of first-degree murder if they were participating in what's called a forcible felony. So it might be like an armed robbery or a burglary, certain types of burglary. They're out with their friends, they're doing crime. They're breaking the law. And in the course of doing the activity, the breaking and entering, whatever they're doing, someone dies. Maybe it's one of the co-defendants. Maybe it's a police officer shows up and shoots and kills one of the co-defendants. Maybe it's the victim of the forcible felony fights back and kills one of the co-defendants. Maybe it's a car accident in flight from the site. And it could really be an accident. All of the co-defendants involved in the underlying felony able to be prosecuted for first-degree murder, which in Illinois, it's our most serious crime, and it carries the longest criminal sentence. So you can imagine in the 90s in particular, but going through to this day, how a statute like that could be used to encourage, some might say forcibly encourage cooperation, plea deals. It could be used to scoop up 5 or 6 co-defendants instead of just focusing on one in a particular incident. Really what it does is it takes young people who are often in these sort of co-D situations, these co-defendant situations, and exposes them to the most extreme punishment in our state. The next question was, I think, Tracy, so how did it change? Yeah. So for any sort of legal nerds, I'm not a lawyer. So I translate lawyer, but I'm not a lawyer. So I will just give that little disclaimer. But basically, the rest of the country, many, many, many other states have a felony murder policy, but it's narrower. And the burden of proof, the standard of what a prosecutor has to show in order to charge felony murder, to charge first-degree murder, for someone who's just involved in the underlying offense, the underlying kind of non-murder offense, that is something that other states have dealt with. And they've changed to what they call an agency theory, which means the individual would have to have some, it's kind of logical, agency in the situation. They would have to have some knowledge. They would have to have some sense that this is where this incident was going. In Illinois, we use what a minority of states use, which is sort of considered the old way, which is called the proximate cause theory. And that's, you're there, you were part of it, doesn't matter how, you're in trouble. So, for murder. So to be clear, the opposition was sort of, we've abolished the felony murder rule, murderers, we can't catch murderers. Well, that's not true, right? We didn't abolish the felony murder rule. We still have a felony murder rule. It's just a slightly narrower one. It's one where you can no longer be arrested for first-degree murder if you were just along for the ride.
All right, well, I am all for that. I have always thought that statute seemed kind of ridiculous. Like, I understand, like, you're going in and you're all going in with guns, and the plan to one extent or another is to shoot, like you're going to rob another set of drug dealers and you're going in to shoot them. You may not be the shooter, but they're going in to shoot the person. They're going to go in and kill him. Mm-hmm. I could see an argument for that, but like someone has a heart attack while you're driving away or spins their car out because they get scared. I have always, I always thought that was questionable. It reminds me of Governor Ryan's task force on the death penalty. And I know that we wanted to create a commission to oversee or to authorize every time a prosecutor wanted to charge the death penalty, because the commission said it's used way too often as a bargaining tool. As a bargaining chip, as a bargaining chip. And then when the person doesn't plead, people have been sentenced to death who should have never even been up for the death penalty, right? Because they refused to plead.
That's right. And because Illinois has these terrible other statutes, for example, we don't have parole for most people. We have truth in sentencing now, which means we don't offer time off for good behavior. You have a situation where a 15, 16, 17, 18, 19-year-old, felony murder with a gun, let's say 2 people died. They didn't shoot them. They didn't kill them. That's what? 40 plus 25, that's 65 years for first-degree murder. And if you were 15, 16, 17, and you didn't kill anyone, and your public defender said, plead guilty to murder, because then we'll waive the gun, the judge will waive the gun enhancement or whatever. And they would say, no, I didn't kill anyone. And no matter how you look at the statute or read the statute to a 15-year-old who feels like they didn't murder someone, of course they're going to try. Of course they're going to go to court. And then they lose. And then they end up with 65 years. Whereas older, and maybe more sophisticated defendants might take the deal. It's the younger ones who don't.
Horrible. Okay. Another change has been this.
Sorry.
No, that's all right. It's the truth. It is the truth. Habitual criminals. And that now the change has been that only felonies committed from the time they're 21 count. Why do you think that change is important?
Oh, it's critical. So the habitual offender law is what other states call the 3 strikes. 3 strikes and you're out. So it's a statute that, again, is often used to up the ante on people who are considered to have been habitual crime, involved in a life of habitual crime. But when did that life start? So if you're a teenager and you're involved in a gang and you have some youthful indiscretions, some things you did as part of getting by, making bad choices, running with a crowd, should that part of your record be held against you if when you're 21 or you're 22, you're still engaged in that behavior, and 23, 24, you're still engaged in that behavior? Again, I don't always agree with the outcome, but you could make a case. There's a strong argument to be made that the older you are, the more accountable you are, particularly when you age out of that sort of time of life when criminal activity is attractive and appealing, and your brain is less adept at dealing with consequences. So this law makes it so that you can't count, the first strike can't be before the age of 21. So that's so it means things aren't accumulating toward that end, which is a really extreme prison sentence, unless it started after age 21 or age 21 and over.
Yep.
It's a big deal.
That's another important. Yeah, I think that's another important step in the right direction. I think, especially for people that are criticizing the bill, I think they fail to realize these are only steps in a overall campaign to make changes, because there's a lot of changes to be made. This one, mandatory minimums. So
yeah.
Well, go ahead, because I know it got changed.
No, you go ahead. Ask the question.
There's a change that now allows a judge, if they, and correct me if I'm wrong, if they think it's appropriate to, I don't know if, I guess the word is disregard the mandatory minimum and possibly offer the person probation or some kind of conditional discharge. Is that correct? Do I got it right? And what are your thoughts?
I think that's correct. I mean, this is not an area of the statute that I'm an expert in, but I will say that if I had to identify one area that really was missing in the larger omnibus, it was sentencing. So it was the idea of it getting at mandatory minimums. This is a tiny little change to mandatory minimums. This is not a big deal. There are a lot of things in this bill that are a really big deal. This is not among them, in my opinion. It's a pretty minor change. Yeah.
So you talked, you just brought up sentencing. So let's go. How do, so is there no chance for parole or very little chance for parole for people in Illinois? Explain that a little bit, because I don't think people understand that.
Sure.
And then I want to talk about the changes for sentencing credits.
Sure. Yeah, this is exciting. So sentencing is one thing. And then post-sentencing, we call it meaningful opportunities for release. So in some states, there are robust parole systems where you can go before a parole board. The parole board can let you out early and on some kind of supervision in some cases, in other cases not. Other mechanisms to get people out early are, we call it good time, earned sentencing credits. So we'll get to that. Parole in Illinois was abolished in 1978. And so right now there are about 40, I think it's 40, it might be a little bit more, it's between 40 and 70, but I think it's 40 remaining individuals in the state of Illinois who have the pre-1978 parole regime, where they get to go before a parole board every year or 2, 3 years, make their case that they're rehabilitated and be considered for release. This is what most states offer, and it's what many of us just assume is there. And it's not there in Illinois anymore, unless you were convicted before 1978. A big chunk of Restore Justice's work in the first 5 years of our existence was trying to bring back some parole opportunities. We would love to bring back parole for everybody. Politically, that has not been palatable. We've not been able to make, basically get enough votes on any bill that would provide comprehensive parole. So we thought, let's get it in place. Let's see if we can start chipping away at the block. So we supported Representative Barbara Flynn Curry, Leader Curry at the time, and now Senate President Don Harmon in a campaign that lasted from 2012 through 2018 to bring back some type of parole. And the parole that was restored was only for people under the age of 21, that 21 age of maturity line again. And it is not every year, every 2 or 3 years, but it's really 2 to 3 bites at the apple in the lifetime of the person who can come before the parole board. And that is what we were able to do. It's not retroactive, so it does not help us solve the really terrible problem of the fact that many, many people who were sentenced during the worst years of the ramp up in sentencing can't take advantage of this mechanism right now, but we're working on it.
Okay, so define it for our viewers. What are sentencing credits and how did that change in this bill?
Oh boy. So sentencing credits are really complicated. So I'm going to do my best to distill it. So in the olden days, in the days of yore in Illinois before 1998, if you were convicted of anything, you got to earn good time off for good behavior. For many people, for most people, it was called day for day. So you got, basically, if you got an 80-year sentence, if you were good for 40 years, you get 40 years off and you go home after 40 years. Some offenses, it was a higher percentage. You had to do 75, 85. I'm not sure if that's accurate, actually. I need to double check that one. My history might be off. But that law that was passed in 1995 that actually was finally implemented in 1998 was the single largest driver of extreme prison terms in Illinois, because what it did was it took, if the base sentence for one homicide is 20 years, and with a gun you add 25, so it's 45 years. You have people who were serving 22 and a half years for something who are now serving the full 45. It's that like that. And I think there was a feeling at the time that in the 90s that judges would sort of lower the ranges, or that they would go to the bottom end of the range. Well, they didn't. So time literally just exponentially increased. So what earned sentencing credits are now, as changes have been made to the law over the years, are less about automatic time off for good behavior, not automatics, quasi-automatic. And it's more about credit for courses taken. So getting a GED comes with a certain number of days off, depending on when you were sentenced. So again, many of these laws are not retroactive. So there are more opportunities available to people sentenced before 1998 than there are to people sentenced after 1998. This particular statute is retroactive. So it does, which is a real groundbreaking facet of this piece of the law. And the champions behind this were the John Howard Association and the Alliance for Safety and Justice. Those are two organizations that I would recommend sort of following for those of you who are into this stuff. We didn't work on this provision, but the thing I like best about this provision, because my population, the people I care about, kind of really advocating for in prison, are people who are serving more than 20 years. So in this provision, in the statute, they, I think based on their learnings from COVID in many ways, the director has always had the ability to offer 180 days of good time off, early release, to people who are engaged in certain courses or for whatever reason are eligible, close to their out date and eligible for this good time. This new statute creates a tier of being able to earn 365 days if you have more than a 5-year sentence. And during COVID, what we found was it's really easy to release people who are really close to their out date if they've got a 2-year sentence and they're 6 months out. But if you've got a 27-year sentence and you're 1 year out, you're out of luck. So this was a way to sort of, I think, create more options for the director and the department in their ability to do early release.
Well, that's kind of backwards a little bit, right? That they're allowing the people who have been in the shortest time to get out earlier, and the people who served 26 out of 27 years. No, you can't get out because I guess the seriousness of the offense to some degree, but God, they've been in 25 years.
Right. I think that's the hard thing. Me neither, because most of the people who we work with have really aged out of any kind of violent behavior. I mean, they may have been involved in some horrible things in their teens, in their early 20s, and then 20 years go by, 30 years go by, and they've got 5 years to go. And there's really not a public safety reason anymore to be keeping them. It's really about punishment. I've heard judges say it in resentencings. You're clearly not a risk, but this is about the offense and we're going to continue to punish you. It's a choice we're making as a society. I don't agree with that choice, but that's the choice that we're playing out. It's nonsense from my point of view.
Yeah, I mean, really, they should, in the next omnibus bill, they should have to show that there's that these people are a risk of reoffending has got to be tied to their being incarcerated. Because I get into this one of the things this bill does away with it to basically is bail. Gets rid of the money bail, cash bail system. And there's been just so much hot water around that, and flame throwing around that same thing. I don't think
It's
people
very similar.
understand what bail's for. It is. I don't think understand people. Like, I think the critics of it don't understand what bail is actually for, and they don't care. They just and I view that to be a conservative liberal thing on this one issue, especially because like the conservatives who are all about freedom and freedom from government intervention in your life somehow have no problem with someone of color being locked up for 2, 3, 4 years waiting for trial just because some officer said they did something. And they're too poor because they don't have the 10 grand. Yeah, that's what I think of. And it seems similar to this. I don't know why we would be lacking. I mean, how much do we have to punish someone if 20 years wasn't enough? I don't understand.
Yeah, I mean, I used to work for an organization called Human Rights Watch, and I had the opportunity to go both to The Hague and to observe courtrooms in the tribunal around the former Yugoslavia. And one of the things that struck me was that the parties to the convention that led to The Hague and that international justice process won't send people into the U.S. justice system. They'll send them to just about anywhere else in Europe, but not to us, because they consider our sentencing regime to be, breaking every human rights standard you can imagine. They wouldn't, even in some of the most heinous cases, anything more than 15 or 20 years is considered completely excessive. And we do it every day.
Yeah. Yeah, we're pros at it. God, throw more money at cops, build new prisons. We are so good at that.
Yeah.
We are pros in shooting ourselves in the foot time after time again. Okay. So I saw that there were changes to the mandatory supervised release. Now,
yes.
And as much as I'm up on criminal justice stuff, when I hear mandatory supervised release, I think parole.
That's correct. So think of parole as being two things. Parole, as we understand it in our popular imagination, is two things. Parole is getting out early. You get paroled out. You get out before your sentence was done. That's one aspect of a parole regime. The other aspect is, are we supervising a person? Are we keeping an eye on them after their sentence for some period of time? When we got rid of parole in 1978, and as the law developed over the years, the aspect of the law that is supervising after release is what we call MSR. And it's the half of parole that is that I got to go see my parole officer. I got to check in with my PO. That's what that is. It's very, very confusing because people in the media still refer to it as parole. And so that makes Illinoisans believe we have a system that lets people out early. We don't. So that's why it's fuzzy.
All right, let me just for clear, I'm sure people out there are thinking this. I know it is in my head. So is MSR supervised released after they serve their 85% of their sentence? It's on top of that. Rather than
correct. It's on top of that.
Cutting.
It's on top of 100% of their sentence in Illinois. 100%.
All right, so that's why it's different than parole, because parole would be
correct.
You serve 40% or 50% of your sentence inside, right, in prison, and then you serve you're paroled out, but you serve the rest of your sentence you serve the other 50% of your sentence in the community on parole, where MSR is you serve maybe up to 100% of your sentence, and then MSR is an add-on.
Yeah, and the judge, the statute judges what you get. So if you dive into the statute, you'll see that there's a set of rules. If it's class X felony, it's X number of years. If it's a class M felony, it's X number of years. So that the statute spells out the old regime and the new regime, and does create opportunities for the first time in a very, very long time for people to leave prison without being supervised, without MSR. And that's where the debate is. So there are folks in law enforcement who I think believe there are certain offenses that someone ought to be monitored after they get out of prison, even if they've served 100% of their time. Having a legislature set those terms without some kind of discretion it's just weird, right? I mean, again, should we be judging whether someone's a risk? Not just based on their offense, but based on who they are when they get out. or when they're preparing to be released. It's tricky.
And if we, I find, I don't think there's a lot of science to back any of that up. I mean, so am I right that they can violate their MSR? When they violate their MSR conditions, they go back into prison?
They do. So in many cases, they do. So I just want to acknowledge the group that did most of the work, or did all of the work as far as I'm aware, on this statute, is the John Howard Association. And so I want to just let people know, if you have questions about MSR and you want to talk about or learn about more of this stuff, the John Howard Association is where to go. So one of the things that drives high recidivism rates is what's called technical violations. And technical violations of what? Of your mandatory supervised release conditions. So I actually had someone parole in my home over the summer. So one of the former juvenile lifers, who we started this organization to help out, was released after 29 years in August, and he lived in my home for 3 months. And he did they call it the house arrest stage of MSR here. So it's a stage where he had an electronic monitoring. He had to check in with a parole officer once a week. And he was required to be in this home for 12 hours every 24 hours. So his curfew was 8 to 8. So he had to be home from 8 p.m. till 8 in the morning, and then he could go out and do business during the day, those 12 hours. He was almost violated a couple of times because the car broke down. He's a few minutes late getting home. This statute prevents those types of incidents from becoming catastrophes. Luckily, there's some discretion already in the process. So we were able, he had a parole officer who was willing to listen, and we were able to deal with, one little indiscretion. But there are plenty of situations where people are violated and end up going back to prison. And it's you can't imagine how terrifying it was for the man in my home, my friend Nelson, who got this terrifying call, saying you've violated the conditions of your parole. He'd been in prison for 29 years. That is not a place he wanted to go back. The guy doesn't even jaywalk. So the idea that that the ankle bracelet went off because the car broke down is terrifying.
It's pretty astonishing to me. I mean, I think the science has proved over and over, the social science, when they've looked at it, is the more of these requirements that you put on in these programs, the more likely people are to fail. And you're kind of setting a lot of these people up to fail for no apparent criminal justice need. This is not a rearrest. You got arrested on a burglary and you're out on parole or MSR.
That's a different thing.
There could be there's an honest discussion to have about what to do at that point, or something more serious than a burglary. There's an honest discussion to be had, but placing them, for being a few minutes late, I mean, there's a lot of those stupid requirements. I know this was, they've done this, and the Social Science, the Vera Institute, has looked at this all over the country, and these programs are really, really bad, but they're very good politically. This is how you get these things.
Right. Yeah. They sound, on the face of it, if you're average John Q citizen, on the face of it, it's like, if somebody did a murder and they did a bunch of time in prison, shouldn't we just keep an eye on them? And they're reentering. Well, sure, but what does that look like? Are we talking about 3 years in Illinois, 3 years on top of your prison sentence, where you have to register in some cases? In addition to registering, you have to also call a parole officer. If that parole officer, we're all human. If that parole officer doesn't take a liking to you, or if you're in a particularly difficult living situation, it can be a powder keg. It really can. And people go back to prison for those things. They don't get help. We had a case that really, it still troubles me a lot. One of the people we've been sort of following and trying to support throughout the years came home after almost 30 years, and his mother and his grandmother both died within 2 weeks of his coming home. I mean, it was just a terribly tragic situation. And he popped, as many people would. And that became a law enforcement situation, not a social service situation. And these are our failures, not theirs. And I think the statute moves us closer. It's not perfect, but it gets us a couple steps closer.
We are very good at building systems that do nothing but fail, right? And we are very good at building larger police departments and bigger prisons and more sophisticated surveillance systems, but we're not good at actually just solving the underlying problems. I know I'm very disappointed, I would say, with the Lightfoot administration's across the board on criminal justice matters. Her outright denial of the defund the police conversation was a massive mistake. And she had the chance to take the first steps in a very big way in the state, and then use the Chicago Police Department as the leader on that conversation, Chicago, and then push the rest of the state. And instead, the liberal bastion of Chicago and an otherwise mostly conservative state, she did the exact opposite. And I think that gives cover to a lot of politicians and mayors and legislators across the state to go, oh no, well, Chicago doesn't want this. Why would we do it? So those things.
Yeah, and she branded herself as a progressive, and that's it's really, I think it's just really clear she's not on this issue, and it's beyond.
Candidate Lightfoot, candidate Lightfoot and president of the police board Lightfoot would be really, really upset with Mayor Lightfoot. Yes, her tunes have changed, right?
Yeah,
we still have
and
right? Go ahead.
Yeah. Oh, I was just gonna say, and I'm all for people learning and changing in the job, right? Like, I'm for, in general, when you get a big job that you've never done before, like say mayor or governor or president, of course there are going to be some things you shift on. Of course you're going to learn new realities. You're going to see the other side of the coin. But and you hit on this, the denial to even engage in a public conversation in a meaningful way, the immediate combativeness, when her stated positions as a candidate she would have been disagreeing with herself and shutting herself down. That's what I find really abhorrent. I don't expect anyone to stay lockstep with their positions when they learn new facts. But her inability to translate that experience to her supporters, and people who the jury was out, that's really a failing, in my opinion.
Yeah, and I'm convinced, and I'm sure you are to some degree, although I'm going to ask you, so we're going to find out, like, if we're not going to solve the criminal justice problem until we solve the economic issues and challenges and the social issues that are facing these communities where crime and violence is most prevalent. I'm all for defunding the police. I'm all for bringing in, we had Cahoots on the show recently, the people running Cahoots in Eugene, Oregon, about alternative response. I think that's wonderful thing, Chicago. We're working on bringing that to Chicago. But unless you realign the economics of these communities, I think a lot of what we're doing is trying to bail out the Titanic with a bucket. There's a lot of people in a lot of buckets. And yes, this bill made things better, right? I criticized MacArthur. MacArthur did this race to excellence or something multi-million-dollar, multi-site thing working on the back end of the justice system. And I'm for that, but the best way to put you out of business, which would be awesome, is to stop the flow of people into the system.
And I mean, yes, I think there's more to it. I mean, I'm not convinced that it's a one-way street, that you fix the economics and the crime issue will be solved. I think we're always going to have some levels of crime regardless. I mean, in communities that have better economic circumstances, there's still some crime. There's still some things that happen. People do stuff. We're human. I think there's the deeply, deeply embedded racism in the idea that as Brian Stevenson would call it, the presumption of dangerousness of Black people in particular.
Absolutely.
The presumption of dangerousness. It goes beyond the economics. It does. It cuts through. And that I think a number of examples over the past few years of the high profile, killings of Black people for jogging or for going to the grocery store or doing their normal business. It shows that it's that deep-seated white fear it's corrupted our legal system to such an extent that even if we fixed the economics, I think we need to, there's a two-way street. And I'll just give you an example. So the bail reform started to chip at this, but people who have loved ones in prison for 20, 30, 40 years are poorer than people who don't. Kids who grow up having to visit dad in the joint have more trauma than kids who don't. It's all part of that cycle. So I think what the Black Caucus did in having an economic justice pillar and the economic justice pillar, 3 of their 4 pillars passed. I think it was health that didn't. But economic justice passed, education passed, and criminal legal reform passed. And they're all just a start, right? They all are going to require decades, of us moving in the right direction. But you got to do it all. You can't, I don't think there's one lever, and I don't think it's one direction.
I agree with you, but let me say that I think that if we could change the economics, maybe it's the first step. I agree with you. Racism is not going to be stopped no matter how much, especially overnight or within maybe our lifetimes. But I just think changing the economics changes a significant amount of the circumstances about why some of these crimes are happening. And it also empowers those communities to actually really advocate for the things they need, because right now they're facing so many hurdles. One on top of so many things that have intersected and hit their communities for 40, 50 years. Anyways, we can go down that path forever.
I don't disagree with you. We could. I don't disagree with you. I mean, I think you're right. And the other piece of the economic puzzle is, and this is something that's hit me in the face during COVID on a lot of levels, is watching how the administration has had to deal with trying to implement COVID mitigations in prisons, is the degree to which the powerful, Democrat union, white Democratic Union member, that voter, that person has an economic interest in the continuation of the policies that we've been disparaging. Yes. And so that's a part of the economics that needs to be dealt with. I think we could funnel money into Black communities all day long. We could fund demonstration projects. We could do, all the best economic development stuff in the whole world. And if we don't figure out how to deal with low to moderate income people who are part of public employee unions who depend on Black bodies in cages for their living, we're in big trouble.
Yep. We are. I had a student come to me maybe the second time I taught a class at UIC during my grad school time. And she goes, I was wondering if you could help us with something in my community. I'm like, okay, I am sure I know someone somewhere that can point you in the right direction. She's like, yeah, they're talking about closing our prison. And it would just be economically, cripple us.
It would devastate
and
their
I'm
community.
Like,
yeah.
Right. I'm really sorry. I appreciate the impact, but I am not advocating for keeping a prison open. I just can't do it. I understand the position you're in because your family's dependent on it and your community and neighbors are dependent on it. I agree. I think that's a huge, one of the intersecting things that is the rural white union member that's incumbent on the prison industrial complex just to survive.
And the police, it's the police, it's the courts, it's the prisons, it's the jail. I mean, it's big. And the thing that really bugs me is that we can't have anything other than a binary conversation about this. As long as it's about being pro-union or anti-union, I'm pro-union. But I would like to have a conversation about the kinds of jobs that those communities could have if we invested in something other than prison to help people. I don't think we can have a conversation about closing prisons, which we're about to have in the state of Illinois because our prison population has gone down and the facilities are a nightmare and they're just an absolute lawsuit machine. These old facilities, these dying facilities. We're going to close some prisons in Illinois in the next few years if we can keep the population down. And that conversation is going to be brutal. And if people on my side of the political fence can't have some compassion for people like your student,
Yep.
I mean, just because we have compassion for incarcerated people doesn't mean we have to shut the door on having compassion for people who are afraid of losing their job. We just have to. We have to break through this. It cannot be a either or conversation. We have to be able to say, well, what could we do? Is there something else our state could invest in that might create a job over here when we're maybe taking one away over there? I get it. I don't think it's reason enough not to close them down. I think we still have to close them down no matter what. But if we can't have that conversation, it's just never going to get better.
I have that same conversation. I have the same thoughts all the time around police accountability.
Yeah.
And bridging the gap, like when talking about bringing in a program like Cahoots and this alternative response program and taking 10, 15, 20, 40% of the calls away from someone with a gun showing up, and the police union goes insane. And it's like, wait a minute, we're decreasing your workload. We're trying to find a way. The most dangerous thing you could show up to is a domestic violence, domestic disturbance. Violence they'll probably still have to show up to. So we can send an alternative response that may have the possibility of finding a solution and ending what we know is most likely going to be a long trail of calls and then lead up to violence and then an escalation in the violence. Why isn't that something you welcome? Right? But that conversation just gets shut down. Even in Eugene, Oregon, where Cahoots is working, it has been on 30 years. And the police are still complaining, still trying to lie about the data about how many calls Cahoots is actually taking away from them. That's 30 years on, and it's a power issue. There's all this combined. It's a money issue. It's a political, for the union, it's political clout. They don't want to seem like they're giving up anything,
like they're
to keep themselves in power, right? Okay, I have one last question for you before I let you get out of here. When we go on to segment 2 here, who were the main opponents of the bill, and what was their rhetoric? Because I'll tell you, a friend of mine who I trust with my life got some messages on Facebook about the dangers of this bill, right? Because it's going through the suburban Chicago parents' Facebook chats and everything. And it was just the most insane rhetoric. So I just wanted to know who you were dealing with or trying to beat in this bill here.
Yeah. On our stuff, the people on the other side of the negotiating table are almost always either the Illinois State's Attorneys Association or a handful of state's attorneys who typically DuPage and some of the other collar counties, who just don't, for a variety of reasons, don't believe that this type of reform is going to do anything but make their communities less safe. That, to me, I feel like we've been in debate with state's attorneys about this felony murder for a while. I think the major drivers behind the Facebook posts and the like were the Illinois Sheriff's Association. And some, individual county leaders in that sort of arena who've been putting out some really horrific stuff. There's a very sort of a Trumpy feeling to some of it. It's a very, it's explosive, it's inaccurate, and it is really easy to consume. So, of course, it's very popular because it's explosive and accurate and easy to consume. And the governor and the attorney general and the state's attorney and the Lake County state's attorney, the Cook County state's attorney, there are several law enforcement officials at the highest levels of the state who were supporting this bill. Elected law enforcement officials, our attorney general, the largest county in the states, and one of the other largest county in the state's attorneys. But the associations of smaller communities, it came out, it smacked a lot of that sort of, that Trumpish fear mongering, and it's ugly. It's very ugly. There were a lot of really good law enforcement people involved and engaged, though. There really were. A lot of good law enforcement people were at the table. It's just those aren't the ones who created the meme that took fire in, suburban white people's homes.
One of the aspects of it that I thought was the funniest is like, can you believe it? They're going to not allow, and I don't even know if this is in the bill, but I read it today, so I had to bring it up. They're no longer allowed to shoot people with their taser in the back. They're not able to tase them in the back.
It's not accurate.
Can you believe that?
I don't think that's accurate.
Well, first of all, it's already against the rules in most police departments to shoot someone in the back because they're not an imminent threat of violence. Because there's medical reasons, you're supposed to shoot them in the stomach. I think there's very specific places you're supposed to tase someone for medical reasons, and that's how the training is. But that was just one of the things that they were yelping about. It smelled a very Trumpian. If there was all I needed was a Q in there, and it would have been perfect. Someone drinking blood or eating babies.
It's true. I mean, and the funny thing is the scenarios that they put in that meme that's been making its rounds on Facebook, the governor did a point-by-point rebuttal that was obviously, it was so easy. It was like he had an answer to it in 10 minutes because it was so blatantly not what was in the legislation that it was really easy to rebut. The problem is those people don't read rebuttals. Like that's not the crowd who's getting their news from, the sources who are covering the governor's rebuttal. Which is another, societal problem we could talk about all day. But the truth is the deadly force stuff is like, it's so common sense. If you actually read the statute, like you said, it's yes, it's big. Yes, it's long. But if you read the statute, just don't kill people unless you're really about to die. Like you can still use force. Just don't use the deadly force.
Right. And
seems pretty common sense to me.
On the taser, the last thing, I have a friend in the CPD that I've had since high school. And he said to me, he goes, I don't understand why we don't get more. This is during the federal investigation. He goes, I don't understand why we don't get yearly training. We don't have any training. He goes, I was just on some task force with the FBI. And they're talking about they get use of force training where they put their hands on people every year. He goes, none of my guys on the job want to put their hands on everyone. They take out a club or they take out the taser. And if someone's even not passively resisting, they just tase them. No one wants to put their hands on anyone. We don't get any training. And he's been out of the force maybe 15 years, out of the academy. He's like, I haven't had use of force training in 15 years.
Well, and the joke's on them. They said this is defund the police. This bill builds in training, increased training opportunities, required training opportunities, but also the budget funds it. That the governor took into mind as they were building the budget. It's in the budget. So it provides more resources for training. Okay. It's not a defund bill.
Really crazy. I got all right, last thing, I swear, but we got
then we got to go.
LinkedIn messages about how, from an ex-Cook County Sheriff guy, about, the de-escalation training, it doesn't work. It's a complete failure. Really? How do you know that? But you don't need facts. This is a factless discussion. When you get into these things, these aren't facts.
Yeah.
Because that's fake.
But the idea of de-escalation makes sense, right? Yeah.
You would think.
Yes. Who doesn't want to de-escalate? It would.
Yeah, I mean, the funny thing is, our entire lives we thought police probably got de-escalation training. Like, wasn't that part of what you'd get through the academy? Is learn how to talk people down from violence? No, just shoot them and throw them in jail if they live. Okay, Jobi Cates, thank you so much for coming in. I really appreciate it.
Thanks, Tracy.
It's been a pleasure.
Great
Hopefully
to see
we
you.
can talk about another one of these soon. Great to see you too.
Love
Take it easy.
Take care. Bye-bye now.
All right. Thanks again, Jobi. We really appreciate you coming
Thanks.
on. Okay.
That was fun. All right. I got to go eat something. I'm about to pass out.
Take it easy.
Great to see you, Trace. Take care. Bye.
You too. Okay, ladies and gentlemen, for our last segment today, we're going to talk really quickly about the CPAC and GAPA ordinances. So for those who don't know, CPAC and GAPA are two different versions of like some kind of community council, community commission to have either some oversight role and some community meeting role, or in CPAC's version, outright control of the police department, excuse me. So For those that don't know, last Friday was supposed to be what was thought to be quite possibly the last hearing in front of the Public Safety Committee, where they were going to once again, vote on passing either CPAC or GAPA. GAPA, I don't remember what CPAC stands for. GAPA, Citizen, CPAC, Citizen Accountability Council. But GAPA is the Grassroots Alliance for Police Accountability. We had Desmond Young on the show some time ago. You can go to our YouTube channel or Facebook page to get that video. If you want to learn more about GAPA, we spent the hour talking about GAPA, the GAPA ordinance. But there was supposed to be this vote, and it isn't exactly 100% clear yet why Mayor Lightfoot stopped that meeting from happening, but she placed a phone call to Alderman Talafario, who runs the Public Safety Committee, and stopped that meeting. We don't know exactly why that happened. But she definitely, well, she said to some extent that she's coming up with her own that is no one has seen, and she's going to get it directly put into the committee, and there's going to be a vote on it. No one has seen it as far as we know. We don't know if anyone has been able to comment on it. We're trying to get some aldermen on the show next week or the following week to talk about what's going on. This is something that Mayor Lightfoot said she would pass in the first 100 days of her administration. This is candidate Lightfoot and Police Board Lightfoot and head of the Police Accountability Task Force Lightfoot, not Mayor Lightfoot. We are now approaching 2 years. 1 year of her administration being COVID, and they can't get this passed. They can't just figure it out. It revolves a little bit around whether or not the commission that GAPA wants can fire the superintendent, and to what degree they can do that or not do that. CPAC, they'd have absolutely control over the entire department. I said this on this show and on social media before. I am against CPAC. I don't think that's the right way to go. GAPA will be... I think GAPA is workable, but there have been so many versions that I can't tell you right now, ladies and gentlemen, what the current version that's up in the city council is. So hopefully we'll have some aldermen on the show in the coming week or two to talk about it, and we can get a little more in depth what's going on. As soon as Mayor Lightfoot drops her version, we will, of course, bring that to you and have a show on it. So thank you so much, everyone, for joining us today. Remember, next week we start Monday, Wednesday, Friday at 5:30 Central. Jonathan Bellew will be on our show on Monday to talk about his experiences covering the George Floyd protest and his response to the Office of Inspector General and the Deputy Public Safety Inspector General's report on the protest, police accountability, and what the police did. Once again, we'll see you. Hopefully, if you're interested, see you tonight at 7 p.m. You can see we posted the link to it. You can come to our nation meeting. We'd love to see you get involved. We have now around 125 people involved in projects, various research projects for CJP, and they're from all over the country. So please join us tonight at 7. If not, we'll see you next Monday at 5:30 Central with Jonathan Bellew.